Legal terms that start with the letter A. To abscond is to secretly travel out of the jurisdiction of the court, or to hide in order to avoid legal process. Absentee, a person who has disappeared or whose whereabouts are unknown. Access, typically referring to family law cases. This is the right of a party to spend time with the children on a regular basis and to receive information on the children's health, education, and well-being. This is compared to the terms custody or custodial parent and visitation. The accused is a person or company charged with a crime or a defendant in a criminal matter. An acquittal is a finding of not guilty in a criminal case. An act is a law passed by provincial or federal legislatures. The court can also be directed to look at these acts or laws in what are sometimes referred to as authorities. An example of this would be an accused person asking a judge to look at the Evidence Act in Ontario to decide on the admissibility of a piece of evidence. In another example, if you were suing a school board in a civil matter, you may look to the Education Act in Ontario as an authority on whether a teacher or principal had a duty owed to you, a lack of which could result in a negligence finding. An action is a legal proceeding in a civil case. A family court case can also be called a family action or a family matter. Just a side note, family court is considered civil law. Actus Reus is Latin for guilty act. It's a voluntary action or omission that, when intentional, results in a criminal offense. In criminal law, a guilty act must be usually accompanied by a guilty mind, or mens rea, for there to be a conviction of guilt. An adjournment is a postponement of a court hearing to another date. If you're in custody, this may be called being remanded. Admissible evidence is evidence that may be received by a trial court to aid the fact finder, either the judge or a jury, in deciding the merits of a controversy. Each jurisdiction has rules of evidence to determine questions of admissibility. Because there are rules for admissibility, if something is admissible, that means it's typically in compliance of exclusionary rules or rules of that evidence being excluded. An affidavit is a written statement or declaration of facts that are sworn or affirmed to be true. An affidavit of service is simply an affidavit certifying that a document has been served on somebody. An affirmation is a solemn declaration made by a person to tell the truth. Lying in an affirmation is perjury, a criminal offense. Being affirmed or giving an oath is basically a promise to tell the truth. When you swear, or it's also referred to as affirming or commissioning an affidavit, you can swear before God or affirm to tell the truth. Aggravated damages are often not awarded, but when they do apply, it is where the injury or damages onto a person are from a wrongdoer's behavior. Examples of this in law can also be found in criminal law, just referring to the term aggravated. For example, aggravated assault is a more heinous or horrific or terrible form of assault compared to just a simple assault. The same is true for aggravated damages. Arbitration is a process that takes place outside of court, where a neutral third party, selected by the disputing parties, makes a decision on the issue in dispute, much like a judge, except it's binding, meaning it's a final decision. A judge's order, on the other hand, can be appealed. Amicus curiae is Latin for friend of the court. If you're representing yourself, you may hear this more often than not. And it is essentially a lawyer who assists the court during the course of a hearing to represent the position or interests, usually at the court's request. An example may be in a sexual assault case, where the court may order that a self-represented party cannot cross-examine a complainant or witness personally, and a lawyer must do so on their behalf. See Section 486.3 of the Criminal Code for more information on how this can be applied to you and your case. There are very specific reasons on how a court can impose a lawyer on you against your will. This is the only statute or law that allows for this to happen in Canada. Otherwise, representing yourself is a common law principle that is deeply entrenched into the Canadian legal system. Subscribe to our channel and stay tuned to see a video on how to defeat 486.3 applications. An annulment is a declaration by a judge that a marriage is invalid. If a marriage is annulled, it is as if the marriage never occurred. An answer is a response to an allegation or an application. Applications in terms of civil court cases. An appeal is a request made to a higher court, tribunal, or authority for the review of a decision. An appeal period is obviously a period of time that you have to appeal a decision. An appellant is a party that's bringing an appeal. An appearance notice is a document that requires people to appear in court to answer to charges. This is to be compared to subpoena or warrant, which will be described in other videos. An application is the commencement or the start of a proceeding in a court by way of filing the appropriate court form. It's essentially a request of the court. An applicant is a person who starts or makes an application. To apprehend means to take or to seize. In child protection cases, it means to remove a child from his or her parents or the person having care of that child, to take them to a place of safety. Only child protection service workers and police officers have the authority to apprehend a child. Arrears is money that is owed to a party under a court order or agreement, but has not been paid. It's commonly referred to in family court cases when speaking of child support. An arrest is the taking or keeping of a person in custody by legal authority, which usually is in response to a criminal charge. The arrest must then be justified to the court why your arrest is lawful. Protection from unlawful arrests is found in the Canadian Charter of Rights and Freedoms. An assessment is the determination of the rate or the amount of something, for example, damages or a fine to be imposed by a judge. In family law cases, an assessment is an analysis by a qualified professional, typically a doctor, who investigates, assesses, and reports on the needs of the children, and the ability of the parties to provide those needs. In criminal law cases, it's a determination by a qualified person to determine the mental condition of an accused person. In civil law, it's a determination of the capacity of a person to manage property, to make personal care decisions, or to properly retain and instruct counsel. An attorney, also referred to as counsel, is a term for lawyer. It's commonly used in the United States. It is also a person who has been appointed under a power of attorney by a capable grantor to act on their behalf. The Attorney General is the principal law officer of the Crown, the Minister of the province or the federal government, responsible for the administration of justice. Thank you for watching. Please subscribe to our channel and make sure to watch our other videos in this legal glossary series. Please also check out our website at irepmyself.com.